right.
What we were talking about.
Okay, well, hello everybody. Welcome to the afternoon session of the ADR section's spectacular presentation of the magic of mediation. The program will provide a look behind the curtain at the rabbits that neutrals pull out of their hats to overcome pre-mediation reticence, in-session roadblocks, and ethical dilemmas to achieve resolutions that provide value to participants and lawyers. My name is Nathan Scheg. I am the ADR section chair. Been practicing primarily in the Bay Area and in the real estate sector for about 24 years. 10 years ago, co-founded Iron Horse Law Group, and 5 years ago, co-founded Iron Horse Mediation Services. And with me is a panel of mediation magicians.
We forgot our rabbit, though.
It's just here.
Starting with Mark LeHocky, mediator, arbitrator, and special master with ADR Services, Inc. Mark previously served as general counsel and a senior executive to Dreyer's Grand Ice Cream and Ross Stores, where he managed all legal affairs and litigation, including intellectual property, product claims, contract, and other disputes. Mark began mediating in 1999. His nationwide ADR practice today includes class actions, IP, insurance, contract, employment, and malpractice disputes. Mark also teaches at UC Berkeley's Law School on the intersection of law, risk assessment, and business decision-making, earned his BA from UCLA and his JD from UC Berkeley. So welcome, Mark. Also with us, Dr. Stephen Sulmeyer, JAMS mediator, arbitrator, referee, special master, hearing officer, and jack of all trades. Joined JAMS in 2019 as a full-time neutral after 20 years as a mediator in private practice, with a dual background as a commercial and intellectual property litigator as well as a clinical psychologist. Dr. Sulmeyer specializes in the settlement of disputes involving professional and intimate relationships. Brings a high level of sensitivity and empathetic skills that are particularly useful in cases involving party vulnerability. His skill at working with the human issues that drive disputes has earned him a reputation for resolving the most challenging, high-conflict, high-emotion cases. Dr. Sulmeyer gained his BA with distinction from Stanford University and his JD also from Stanford Law School. Welcome, Dr. Sulmeyer. Also on the panel, Ms. Claudia Viera. Ms. Viera is highly experienced and tenacious attorney mediator who primarily focuses on employment, contract, and business disputes. Ms. Viera draws on her years of legal experience as an employment attorney with Littler Mendelsohn, the largest employment and labor law firm in the nation, to promote effective communication and increased understanding between parties in conflict. Since 2001, Ms. Viera has mediated nearly 1,000 tough legal disputes. Her most recent work includes race harassment and discrimination, wage and hour class actions, disability discrimination, wrongful termination, sexual harassment, business dissolutions of partnerships, age discrimination, and landlord-tenant disputes. Ms. Viera mediates in Spanish and has extensive experience with pre-litigation disputes in workplaces and among co-owners or business partners. Ms. Viera received her BA from University of California, Berkeley, as well as her JD from the soon-to-be not-named Bolt Hall. I went to Hastings, so I have the same problem. Okay, before we start, I have been commanded to do some housekeeping announcements. If you're taking the course for MCLE credit, sign in, please. The sign-in sheets are goldenrod in color, and I see them in the back of the room. Links to materials are available before today, were emailed to you on Wednesday, also available on the MCLE Spectacular page on the CCCBA website. Your attendance certificate will be available and emailed by mid-December. And please fill out the evaluation form and drop it in the box at the registration desk. For those of you who love the presentation, tell all your friends it's being recorded in the back. And thank you everyone for coming to the 28th annual MCLE Spectacular. So, with that said, we can dive into the magic of mediation. And sometimes, well actually before we dive in, let me get a little audience straw poll here. How many of you are mediators? Okay. How many of you are practicing attorneys? Okay. Not mutually exclusive. And how many of you are neither? Okay. All right. That gives us a good idea. So, oftentimes, the magic of mediation has to start as early as pre-mediation. And so I would love it if one of our panelists jumped in and talked about some pre-mediation magic that they utilized.
I can start us off if you like. So, in some ways, I think that preparation for mediation is one of the most important things that anyone can partake in, and that includes us as mediators. But one of the ways that I think, and we all have different practices probably, so I'll be interested to hear the other panelists speak, but one of the ways I think that I can be most effective and helpful with individuals pre-mediation is by holding a joint pre-mediation conference call. And I'm sort of curious, how many of you as attorneys have conversations with your mediator prior to actually mediating? So I'd say like maybe a third to maybe 40%. How many have tried to have conversations with a mediator and not been given access? Anybody? Okay. So that happened to me though when I was practicing about 15, 20 years ago or so. That I had a JAMS mediator, sorry Steve, and couldn't get access. Couldn't get access, right? Was basically told by the assistant that talking to the mediator in advance was not possible. And so one of the things that I think that I do as a result is I hold joint pre-mediation conference calls with both attorneys on the line at the same time. Part of the reason that I do that is because it allows me to get a read on how they're working together, right? Are they effective together? Are they collaborating with each other? Are they actually at odds with each other? All of that is helpful information as a mediator to know in advance. The other reason I do it is we actually have substantive conversations about the process. So literally, do you want to meet in joint session? Would your client need an opportunity to talk in joint session to the decision maker on the other side? Questions like that, in addition to very practical exchange of information agreements. So for purposes of mediation, is there something that you need from the other side that will allow you to properly evaluate the case? If so, what is that? Can we make an agreement that will be turned over, for purposes of mediation within, 2 weeks or a few weeks before the mediation, so that each side has what they need in order to actually evaluate the case fairly. So for me, that would be one of the things that I think is actually really, really helpful. And my guess is, how many of you have had joint pre-mediation conversations with your mediators? So a third, maybe less than a third. So it is not necessarily the most common practice, but I actually think it's incredibly helpful.
So, apropos the title, Magic Mediation, I just recently rewatched an old B movie it was called Light of Day with Steve Martin. I watch all Steve Martin movies because people periodically tell me I look like Steve Martin. And I try to remind them that he's much older. But in this, the storyline is Steve has a group that basically go carnival to carnival, and they do a show which involves Steve being a mind reader. And of course, he's not a mind reader. What he has is a contingent of people that walk around before the show and chat with people to collect information. And then they feed it to him through microphones. So when he's standing up there, he knows what the crowd's history is and how good his background is. So I think about that as sort of my model. My job for the preparation to the preparation topic is to learn as much as I can. I come from the background of having been a litigator and general counsel, and I've done this for a while. I believe that the merits of every dispute is really important, but it's not often what unlocks the question I always have, which is, how did we get here? And lawyers do really good jobs in submitting mediation briefs and the like, which typically focus on the merits and the facts, and that's all good. But oftentimes they don't explain to you up front how they got there. So I don't use joint calls usually early on, but I definitely set up separate pre-calls because I'm trying to test as much as anything else. Why are we here? Why do you need me? Why couldn't you solve the problem without me? And the range of answers, it covers an entire map of issues, client relationship issues, sometimes if there's in-house counsel involved, in-house counsel relationship issues, sometimes things relating to coverage and what's happened before. So my version of that movie is I want to collect all the information I can so I can make more informed, I can help you be as informed as I can. That's work, and it's investment in time by the neutral. But I found the people who do that the most, are usually the most effective. So that's one of my approaches.
I'm just curious, how many people here have ever felt frustrated in any case or dispute because you couldn't really talk about what was really going on? Anybody? Am I the only one? Claudia would say, maybe a third. One of the reasons why I've got these extra letters after my name is because I got really frustrated as a litigator that we could not talk about what was really going on. We were constrained by the rules of pleading and the rules of evidence and so forth, rules of civil procedure, to think only in those particular boxes. But as Mark was just saying, why are we here usually points to things beyond just the legal. Why are we here? How did you get here? How did this dispute start? Before it was a legal dispute, it was a human dispute. And so part of what I try to do in the pre-mediation conference call is see if I can find out a little bit about what happened before it was a legal dispute. What's driving this? We can frame it in terms of causes of action and so forth, and that's important. That shouldn't be neglected. But at the same time, we shouldn't neglect what's really driving this for the parties. So one of the things I try to find out during a pre-mediation conference call is there room, or would it be helpful for me to meet with each side before we actually meet in mediation? I find this particularly useful in divorce cases, probate cases, elder cases, family business cases. We've got lots of obvious relational dynamics going on, but it's not limited to that. I had one pre-mediation conference call in a patent infringement case, and I ended up requesting to meet with both sides because there were some unusual causes of action in the complaint. Instead of just infringement, there was also breach of a non-compete, and there was a breach of a non-disparagement clause, and individually against a party, which is unusual in the patent infringement claims. Anyway, I met with both sides, and what I found was that the president of the defendant company used to work for the plaintiff company and had been discharged, he was the fall guy, according to him, for a bad quarter, bad performance. And sure enough, he was bad-mouthing his former employer, and that was what was really driving the case. So by the time we actually met in mediation, I was able to actually just sit with the two CEOs, and we settled the case actually quite quickly because we were able to talk about what was really going on. So just another thing to think about, if you're going to think about pre-mediation conference calls, is see if it might not make sense to meet with each side separately and get to what would be underneath a mediation brief or even an opening statement.
And of course, once you get past the pre-mediation conference, you're smack dab in the middle of sometimes an emotional mediation session. Besides emotions, other challenges and obstacles often come up during the process, and you need to figure out ways to get past an impasse. So if the panelists could discuss some examples of challenges and obstacles that you've encountered during mediation sessions that might be memorable to you, and how you got past an impasse or roadblock, I would welcome it.
So picking up on Steve's, that's okay, on Steve's last statement, one of the things that I think is really helpful when the roadblock or the impasse is in some way, as a mediator, you sense it's related to the emotional relationships between the parties, is to hold what I call a mini mediation within a mediation. So this used to be a lot easier in the days, 20 years ago when everyone actually was open to joint sessions and so forth. Nowadays, it's a lot less common, but I still offer it in situations where, for example, in one case, the discharged employee was also the tenant of the employer. So you had an employer who was also the landlord who had terminated or fired the employee who was also his tenant, so the tenant got evicted. So it was, and the sad thing about it was it had been a very long-term and very positive relationship between the owner of the property and his employee. The owner talked about him as having treated him like a son for many years. So it was a very sad situation on both sides. And by the time they got to me in the mediation, it had been 2 years, they had not been allowed to talk to each other. And the employee/son was so angry that we got to a certain point in the mediation and he didn't want to move any further in the negotiation. And I said to both sides, or I asked, would you like me to meet just with the former employee and the owner of the property or the former employer together in one room to talk about what happened between them? So I said, we will not talk about the financial negotiation, we will not talk about terms of settlement, we will not talk about money. This is just to speak to, what happened in this relationship that caused it to break down so badly. And who do you think, in which room do you think was the most excited person in the room when I said this? Do you have any thoughts?
The father.
The father? Not so much. I was surprised. I thought he would be the insurance representative who was there with the father, or the father. He's not a true father. But immediately that insurance rep started talking to the defendant, basically saying, here's what you need to think about, here's some things to say, here's what how you should approach this. It was very interesting to watch this sort of coaching mentality start up so quickly. And so in the end, both counsel agreed that I could meet with both clients, both parties, without them. They all sat in separate rooms from each other, away from us. And we had a 1 hour long conversation, just me, the owner, and the former employee. And within 30 minutes of that individual session, or the mini mediation within the mediation, within 30 minutes of that resolving, the case resolved, right? We were done. Because the block was really an emotional one. And, to his credit, the defendant in that case, was very conciliatory and offered a hug to the young man at the end, the one he had evicted and fired and so forth. So there was definitely a piece that was relational, that was sort of an olive branch that was held out. And the plaintiff got to say what he needed to say, right? And express some of that anger and hurt that was sort of at the core of that lawsuit for him. So a lot of this will not be something that you see in an ordinary sort of caucus mediation, but I think that if you yourself are thinking creatively about what your client needs in a situation like this, you could talk to the mediator about creating a process where this might be a piece of it. I don't offer this in every mediation by any means, but when I think that that's somehow at the core of where we're getting stuck, I definitely bring it up, and as I said, it's been very successful.
Claudia, could you give some tips to people who might feel a little nervous about having that conversation?
As the mediator or the attorney?
As the mediator, how you sort of have the perspective and feel confident enough to manage that conversation.
So not every mediator has the skill set, I would guess, for this kind of a conversation. So I come from a background, of high emotion conflict cases, like in terms of employment cases, landlord-tenant cases are often that way also. So I have a certain level of comfort with conflict, right, that's happening right in front of me. And I think practice. If your mediator has had practice working with folks in the same room, for example, often divorce mediators have this kind of experience, right, where they're working with two people. you do too, family law, family lawyers. So I think that those things, if you've had practice, you could also get your practice through a community-based mediation center. So I always think that mediators come to this practice with two different types of skill set, and to get both is challenging. You either have the legal skill set, right? You're a retired judge, you've got 30 years of practice under your belt, or you're coming to it from a more therapeutic or facilitative mediator perspective, which in terms of trainings and so forth, the community-based model is much more around that. So it's about seeking to gain comfort working with people in the same room. So I think if you have a case like that, you might consider looking for a mediator who has that kind of background or experience. I think that would be a wise thing. And if you're someone who wants that kind of experience, I encourage you to go find places to practice that. Arguing about rose bushes can be very helpful in terms of figuring out how to empathize, right, with neighbors who have, growth of rose bushes over the fence line and stuff like this.
Or rosebuds.
So quick shout out to Emily and everybody else for this family law mediation. I've been writing for a number of years about practice. Oh, sorry. I've been writing for a couple of years about how we can do a better job as neutrals. And one thing we can do as civil mediators is borrow from our family law compatriots. I'm going to disagree with Claudia, which I never do, except for this one. There's another category of people out there besides the legal people and the soft skills people, and that's people that do a variety of different things. So I spent 12 years as general counsel after 20 years litigating. Please don't do the math. I don't want to explain the whole thing. And part of that life, which I didn't really appreciate, I had no plans to be general counsel. A client plugged me in, put me in an office, said, you figure it out. That's what I had to do. And I realized you spend a lot of your time with different constituents, your executive team members with different agendas, your board members, members of the public. And you have to figure out what's going on there, and you have to figure out how to work with all those different audiences. What carries over for me, really helps me when I'm dealing with those difficult situations, is help people step back from the dispute, including my executive team. I used to work with Steve Jobs, among others, and lots of stories to tell there. But one of the biggest challenges I think sometimes parties have, and their lawyers have, is how they are invested in the dispute, and how the outcome of the dispute is the end-all, be-all. We must win, we must not lose. What I think is hardest sometimes to do is step back from that and say, what is the toll this is taking upon you, and how important is that? And I can give you some hysterical examples in one of my executive meetings where people said, we must win. And I would say, do we really need to win, or do we need to make it go away? Because I'm worried about all these other things that are going on while the dispute is taking place. One of them is money, but it's importantly, it's time, focus, energy, and the like. Now, I'll take that from a big corporate setting down to a small setting, and I don't recommend this, but I'll tell you the story. But I had a dispute involving a small business entrepreneur type with a company, and they had a contract dispute. And this wonderful man came in, I'm going to call him Bob, and while we're chatting over the breaks, and of course I realized he was even older than me, and he was describing other things, his life when he's not dealing with a dispute, including the fact that his wife was having health problems and she was declining. Then we turn back to the dispute. He's arguing with them, and he's calling them liars, they're calling him liars in separate meetings. And finally I turned to Bob and said, Bob, there's only one liar that I see today, and it's you. Now, imagine what his client, what his lawyer did when I said that. It's like that cartoon where the guys go, oh. And I said, Bob, the only lying that's going on is you're lying to yourself that this dispute is worth your time, your energy, where you are right now. You need to put this behind you and move forward with your life. And thank God, or I could be telling this story, thank God he said, you're right. And guy through Laura's eyes and we resolved it. And I don't recommend that because it could have gone the other way. And I would be telling the story. But it's just a far extreme of the job we have sometimes as mediators, helping people see the dispute, as I used to do with my companies, is they see the dispute in a bigger context. When people really want you as the lawyer or the neutral to say, you're right, we're going to win, and the battle's worth it, it's often not. And I think the best we can do is, our job, is to help them see that broader perspective.
Reminds me of a story I heard Tony Piazza tell once. He also said to one of the parties, I've been studying your case for 2 months. I know this case inside and out. I know it better than you do, and you're wrong. Tony Piazza can get away with that. I guess Mark LeHocky can get away with that. Anyway, I want to say a little something about impasse. I'm a writer. I like to pay attention to language, the thing that I do. And I noticed that we often use things like cut through impasse, defeat impasse, destroy impasse, get past impasse, usually rather martial metaphors. And I recommend trying on and see how it fits. You can always take it off if it doesn't. What if it were understanding impasse? Impasse itself is a message, is trying to say something to us. One of the things that I have found to be frequently true is that impasse is the result of a conflation of the legal and emotional aspects of the dispute. I rarely actually find an impasse that's about, like, there aren't enough pieces of pie. That happens. But what do I mean by this? I'll tell you a story that I hope will illustrate what I mean by this. So, a couple came to see me. They had been divorced for, I don't know, 10 years or something like this. An older, middle-aged couple. They had 2 kids in college. And they wanted my help reaching an agreement on how they could fund their kids' college education. And following Mark's lead, I asked them, well, help me understand why you've not been able to sell this on your own. And immediately they started pointing the finger, making a lobbying accusation. She's lying on her income and expense form, and he's intentionally underemployed, and blah, blah, blah. I said, okay, that's helpful. It'd also be helpful, just tell me a little bit about your kids. And I remember wife said, we didn't come here for psychoanalysis. We just want help with the numbers. I said, oh, that's fine. I'm happy to help you with the numbers, and it would be helpful for me in that regard if I understood a little bit more about the context in which this dispute arises. So what's going on with your kids exactly? And Mom proceeded to say that the son was a pothead who did not want to study anything that had anything to do with making money or having a career afterwards. And the daughter had said to her, Mom, I want you to sell your house and use the proceeds of sale to pay for my college expenses so I don't have to be saddled with student loan debt when I graduate. Okay. And then Dad said, yeah, my son said to me, Dad, Mom's paying me X and you're only paying Y. You don't love me as much as she does. Okay. So this is useful information, but it wouldn't show up in the pleadings. So I didn't quite know what to make of it. I knew there's, okay, we got some entitlement issues here, but what's happening here? So I did something I do when I don't know what to do, and I imagine a few other people in the room who have felt this way once or twice. I call it going stupid, or going subcortical. I just try to be blank, just try to empty my mind, and just sit with the not knowing. And so I just looked at this couple, and they look at me, and they're wondering, why is he staring at me? And then the light bulb went off. I said to them, help me understand something. Why do you two need to reach an agreement on how you're going to fund your kids' college education? In other words, Mom, what's keeping you from saying to your kids, here's how much I can afford to contribute to your college education? And Dad, what's keeping you from doing the same thing? It seems to me you'd rather have a difficult conversation with each other than have one with your kids. And they look at each other. And they stood up and they shook my hand and they walked out. So this is an example of probably several things, but I think it's a way of not looking at impasse as something to be cut through so we can get to what's important, but rather, what is the impasse trying to tell us? There's something, there was what I call a missing conversation that had not taken place. And when I just simply pointed that out, and the fact they didn't even need to have it, they realized, oh, right, I can just say that to my kids. So that would be just one way of answering Nathan's question. Probably we could all come up with several more.
So in fact, they did need the psychoanalysis.
So did their kids.
They had the right person for the job. During mediations, hopefully not all the time, but I'm sure some of you have experienced ethical dilemmas, whether it's involving the parties or potentially yourself. I'd be interested in what types of ethical dilemmas you all have experienced and how you've dealt with them.
I'll also bring our magic to bear.
I want you to start.
You do. So one of the most challenging ones that I dealt with involved through the process of talking with both plaintiffs and defense room. This was an employment case, a sexual harassment charge had been brought by a waitress against her manager. And in talking in both rooms, it began to be clear that in the defense room, there was a new employer, a new owner of the restaurant. But as I worked on the timeline of what had happened when, it also became clear that there had been a prior owner of the restaurant and that the majority of incidents had actually happened during the prior owner's tenure. The prior owner was not involved in mediation. And I don't know why, I didn't know why, but this sort of, my understanding, all of our understanding sort of evolved together in both rooms as we worked through what was going on. And so what became very clear is that in the plaintiff's room, they hadn't followed up with the second defendant, and so the second defendant was not in the room. So that the correct defendant had not been charged, essentially, or had not been litigated against. And so, of course, you all can imagine what that means. It's a very uncomfortable conversation about why your $1 million case actually is really only worth $100,000 or something like that in the plaintiff's room. So it was very challenging because the plaintiff's attorney spoke English, and I and the plaintiff both spoke Spanish, and there was no interpreter. So the attorney was hoping that I would be the person who interpreted for him, which is a very uncomfortable situation. I no longer do that. I now ensure that all attorneys who are bringing Spanish-speaking or other clients bring their own interpreter with them to the mediation. But because what that did was leave the knowledge residing in me and the attorney in the room that the client didn't understand, because a lot of the conversation had happened in English where we sort of sorted out what went on with these two different owners of the restaurant. So in that case, I didn't actually do this, but what I would do now, because this involves a very difficult conversation between the plaintiff and her counsel, right? So what I would do now is invite the plaintiff's counsel out into the hallway and have the conversation and ask, are you going to tell your client or shall I? Right? Who's the best position to have this very difficult discussion with the client around what happened here? And clearly the answer is the attorney, right? I don't think at all it's the mediator. But if for some reason they wanted my help to do that, they could. Because there are implications of malpractice and very other things, right, that go on here. And this was a situation in which, in the end, I trusted that he had that conversation with his client, and I do not know. In other words, in real life, I don't know. I didn't verify what happened when I was out of the room, but I did suggest that that information needed to be discussed. I think of these ethical dilemmas as something that has to sit right within the rules of professional conduct, but it also has to sit right within you, right? Your heart of hearts. And some of us wouldn't care at all, about the situation. Others of us would feel we needed to be more proactive in making sure that the client or the party fully understands what is happening in that particular situation. So I don't know if that's magic. I think it's just a technique for ensuring that that kind of a conversation doesn't go unhad, right? That it's important to actually ensure it happens. And what happened in that case is they still wanted $900,000 despite this fact. And so the misunderstanding was actually getting in the way of negotiating something much more reasonable. And so the mediation ended that day without an agreement. And then on the following Monday, I had a very extensive call with the plaintiff's attorney, and I laid it on the line and said, look, here's your situation. And eventually it settled for, $105,000 or something like that. So something that was appropriate. But, it's difficult in those situations where things like that come up. I think it puts the mediator in a difficult position. It certainly puts the attorney in a hard position too.
So Claudia, are you saying that the ethical dilemma was that the plaintiff's attorney didn't file against the perpetrator and committed malpractice potentially?
For me, the ethical dilemma was, how do I ensure that the party, the client, has a complete understanding of what is going on from a legal standpoint, given that the attorney does not speak the same language as his client. So that was the challenge for me. There was the question of malpractice, but I didn't feel like that was my risk. I didn't have to resolve that, but it was definitely in the room. And what do we do with this now that that's there? Because we were not going to get the defendants who were in the room up above, what they deemed to be a reasonable amount.
How can you get consent to proceed with mediation when the plaintiff herself couldn't communicate with her attorney, at least because of mediation?
So there was some communication. Well, I never know this until I show up at the mediation. In those days in particular, people don't always ask in advance, so they don't always reveal in advance that there's a language barrier or anything like that. I'm better at asking about it now, just to be sure to get that problem in the bud, so to speak, nip it in the bud. But in that situation, there was enough understanding. In other words, it was easier to speak in Spanish, but she had fairly decent comprehension in English, but it wasn't clear to me that she had comprehension of these legal ramifications of what these facts entail. So that was part of the difficulty. Or for me, that was part of the difficulty.
I experienced a situation where an insurance company hired a lawyer to represent a Chinese defendant in a huge landlord-tenant case in San Francisco, and the insurance defense lawyer was from the Chinese. We're in a mediation, and there are punitive damages at stake here. This poor lady literally did not understand what was going on, and I had to say, we can't go forward today. Asked her who she'd like to bring to help her. She brought her son into the next session, Stanford educated kid, and I had this discussion with him about your inheritance risk here, and get him sued to his mother. That's really, it's a very difficult. What do you do as the mediator where one party has huge exposure and they have an insurance defense lawyer who cannot converse with them? That was a very difficult.
And even when they can't converse, because it's my life cases I deal with, there's often coverage involved, and sometimes the parties, the insurance coverage counsel's there, and there's been a clear discussion about the limits of coverage, reservation of rights, and sometimes it becomes apparent through the course of mediation or offensive in that conversation, and the parties are not informed. And so it has nothing to do with whether they speak Mandarin or English. It has to do with they don't understand the risk profile. This comes up a fair amount. My work around or work through is to just be very upfront with everyone and say, we need to always talk about what happens if we don't settle today. And the coverage counselor, the counselor that's there, I incrementally move up to the most direct conversation. As you know, if this doesn't settle, your client has to be fully informed about this. Do you want to tell them or should I? It usually gets over the hump. I mean, and frankly, it's the same thing when I see malpractice issues, and they do come up periodically in cases. I handle it the same way. Let's talk about what Plan B looks like. And I always do it with the clients too, even in the absence of malpractice, in the absence of coverage. I really want to make sure we have a rigorous conversation about what happens if we don't settle today. Because again, it gets too focused on what we're going to land or somebody else is paying the bills. I said, bigger picture, let's look at the whole thing. And people that have not been through a dispute, certainly a big complicated dispute, or something takes some amount of time, normal people don't understand what it really means to them. So I go out of my way to say, can we start counting hours? How many hours do you have that are free time that you have? And make sure they understand, because people have this kind of narrow image of real people. It's only, we'll show up for today, there's one deposition, there'll be a trial in 18 months. Let's count all the increments between now and then. I mean, whether you're talking about to an individual client or a large corporation, I really want to make sure everybody understands what that investment is. The article I just finished is really focusing on that topic. And what cost is the title, because cost is often simplified as it's dollars, and it's much more than dollars. Or it can be dollars, but it's dollars in a much more painful way because of the diversion of time, energy, and resources. So again, I'm just here on the simplest side of, let's get more and more explicit about the conversation we have to have, because the only way we're going to settle the case fairly is people making informed decisions, and then helping people be informed.
So I'll say something in a moment about an ethical dilemma I face, but I first want to say something about magic. I was a magician when I was in middle school, and my partner was a guy named Sean Cassidy. He went on to become a big teen idol. His fans were like 8.
Seriously?
Yeah.
Can you tell me that?
And,
I was one of those teens.
you were one of the I was with Sean at a restaurant in Calgary, and the waitress said, I hope this won't seem out of line, but when I was a kid, you were on my underwear. So anyway, we had a magic show. We were 12 years old, 13 years old. And one of the things about being a magician is that it's not really magic, right? We had this thing where we did make a live rabbit appear. It wasn't out of a hat, it was out of a box. We had this box and it had a balloon in it. And we'd say the magic incantation and wave our magic wand and it'd be a big pop, and the balloon would pop and there was a rabbit. Well, what you don't know is if you turn the box sideways, you'll see there's a little black felt-covered partition and the rabbit's on this side, and when the balloon bursts, because there's a little pointy thing on this thing that you push without anybody seeing it, then the weight of the rabbit then simply pushes this partition down, and lo and behold, there's a rabbit. I can tell you about how a lot of magic tricks work, but the idea is the same, that there's always some fancy trick, but it's not a magic trick. And I think the same is true, at least from my perspective, with the various things that might look like magic to somebody on the outside, but it doesn't feel like magic to us, at least not to me. It's more like, how can we look at this from our various perspectives and see things that might not be apparent on the surface? So that's my little pitch on magic. Now, about an ethical dilemma. I had an employment case. It was a wrongful termination and sexual harassment case. It involved a mental health professional who had a particular kind of business. He wasn't just doing therapy, he was doing some other kind of work with different companies. I can't remember now the details. But anyway, he was a sole practitioner. He had a young female assistant. She was probably around 20 or so. He was probably around 60, something like this. So a big age gap there. And they both told different stories, but she accused him of being sexually inappropriate and harassing her and ultimately firing her when she complained. And so I did the pre-mediation meetings with each party. And after doing that, it seemed pretty clear to me what was really going on. And by the way, I will add that at the time I mediated, I was about 60, and I had a young, attractive female assistant who was about 20. And I'm like, what is the universe trying to tell me here? But anyway, and that may have helped, because there was definitely some chemistry, shall we say, between myself and my assistant, but we handled it maturely because we talked about it, and that we weren't going to act on it. This guy was not quite so skillful, shall we say. He was in an unhappy marriage, big difference between me and him. And he wanted to test the waters, he wanted to push the barriers as far as he could, and he went a little too far. Nothing was consummated, but he was acting inappropriately. And she came from a very unhappy, broken home, and was really looking for a father figure. It seemed pretty clear to me, and he was that father figure, and he was in this sexless, loveless marriage, and he was looking to have the sparks rekindled, and so they found each other somehow. And whatever was inappropriate seemed to be something that was mutually co-created by them. And it seemed to me, as the mediator, having spoken to both of them, that if they could just talk honestly about what had happened between them, that's where the resolution might happen, because that's the truth speaking. And so I talked with both of them about this, and in the morning session, the defendant ended up with a joint session, and the defendant spoke directly to his former employee and said, this is what I think was really going on, and I'm really sorry. I was out of line. I acted inappropriately. There was a chemistry between us, but I should have just called it and said, okay, this is here, that happens between human beings, but we mustn't act on it. We took a lunch break. Then the lead counsel for defendant showed up. He had not been there to hear this confessional, unfortunately. And I met with them separately and talked about what had happened in the morning session. And the lead counsel would have none of it. He is a perpetrator, he's a rapist, even though that wasn't even an allegation, but whatever, he's a sexual predator, and he needs to be punished. And the ethical dilemma was, I know you're taking this on a contingency basis, and I know you're programmed to see things that way, but I've actually talked to these people and you haven't. So the dilemma was, do I push my version of what I think happened on the parties and on counsel? How many people have ever, as mediators, have ever been in a mediation where within just a few minutes you knew exactly what the right result was? Right? That happens all the time. So it's not an uncommon dilemma, but in this one it seemed like, oh, this is so beautiful. If they could just step up and say, yeah, we flirted and we took it too far, but come on, we're human. Maybe there'd be some nominal pain and everything would go away and they could leave with more mature people. But counsel wouldn't have it, and the plaintiff wouldn't have it. She knew what had happened. She talked to me about what had happened. But she was towing the counsel-approved line, and no, he's evil, he needs to be punished, we need to make an example. And they just wouldn't go there. And I felt, okay, I've done what I can, and we settled the case, but not along the lines that I wanted. So there was a dilemma, that's how it was resolved. I still feel, gosh, I wish it had turned out differently, but that's how it turned out.
So that's a good example of when a counsel and client's interests diverge. Oftentimes, more often, well, I'm not going to say more often than not, occasionally you'll come across a situation where you realize the lawyer's not doing the client a service as far as ability. Let's put it that way, right? They're not prepared. They don't understand the law. They're just steering the client in a really bad, incorrect direction. If you've experienced that, how do you deal with that situation?
That is a tough one. I mean, I think we've all probably seen that at some point or other. It's a really challenging situation. I tend to focus primarily on collecting. So my belief is we each come into a conflict situation understanding half the story, right? So the plaintiff has his half, the defendant has her half, and now as a mediator, my role is to help both sides told both halves of that story. So there's a lot of education that has to go on, right? I think that's the morning part of the session, usually when we're discussing the facts and we're trying to clarify things. In the old days, we did it in joint session. So, you know, plaintiff could say what he had to say, defendant could say what she had to say, both attorneys could speak also. So we are all holding the whole problem together. Because if you don't do something like that, who is the one person in both rooms who has all the knowledge? A mediator. So who is the one person who could resolve that dispute? Right, that's the perspective. So it puts a huge amount of pressure on the mediator to figure it out. So going back to your scenario, if you've done enough in terms of educating, right? I think of the entire mediation as an education for the parties in both rooms about all the possible alternatives, right? To pick up on Mark's point earlier about what happens if we don't resolve this today. I have that conversation in every mediation. And not because they've reached anything that I no longer want to say the word impasse, but not because they've gotten stuck, right? But more because I want them to have the whole understanding so that they can make the best choices for themselves. So in working with a situation where the attorney's unprepared or hasn't done a good job representing their client or whatever it is, you know, I think I spend some time talking to the clients anyway and getting the information on the table. And then I do, with the help of the attorney, have a conversation about the strengths from a legal standpoint and the challenges from a legal standpoint. And this is happening in separate session. I do it by way of a risk analysis, and it's always very elicitive rather than directive. So I'm not someone who will come in and say you have a 50% chance of winning this case or losing this case. I ask the attorney, you know, what do you think is going to happen at summary judgment? You can win or you can lose. What's your percentage? Give me a percentage, 80-20. 60-40, you know, and then, okay, so let's say you make it through summary judgment, what's it going to be when you get to trial? You're going to win or you're going to lose. What's the percentage likelihood of that? And they tell me. So I gather, I sort of talk the attorney through this entire process of what happens if we don't resolve, but also what can the party look forward to, right? What is the likely chance of this happening or not happening? And a lot of times attorneys will say, well, we have a great case. And I say, so what percentage chance would you give it then at trial? 55% chance of winning. You know, and that's if they're honest. Sometimes I get the attorney who says 95% chance of winning at both proportions. And then I say, okay, so we're going to take your percentages and we're going to do this analysis. And I do the whole decision tree. And then I say, would you like to hear what, or see what this decision tree looks like with what I deem to be more realistic percentages? And it's a question, because they can say no. And 95% of the chance they say yes, or 95% of the time they say yes. And so then I do it with 50-50, right? I'll just run the decision tree with 50-50, and then they can see the range, right? So that's one way of kind of dealing with the unprepared attorney, is to help educate the client fully by utilizing the attorney's knowledge of the case and the facts and the law and so forth. And that can be easy and not easy, depending. But to me, it's really a conversation. It's a conversation that is about educating everyone in both rooms so that they can make the best decisions possible for themselves. And how you get there might vary, but ultimately, I think the folks involved in the dispute are the ones who are best situated to make the best decisions for themselves, rather than me on the outside or something like that.
One thing I notice in a lot of mediations is the lawyers, instead of the clients, vilify the people on the other side. And terrible client on the other side, incompetent lawyer on the other side. And I try to address that by saying the safest thing for everybody is to assume people on the other side are really good at their job. When you make assumptions about your decisions based upon you're smarter, they're dumber, mistakes happen from that. So I think it's always better to assume the best lawyering. So when we do the Plan B analysis, I will sometimes offer, I think if this case doesn't resolve, here's some things I think could happen. And I may pepper into that some things that the lawyer on one side hasn't brought up so far. because I know it's going to come. And I know maybe some people consider that controversial, but my job is to help them. And my help them is to say, don't make assumptions you're the steamroll the other side. Don't make assumptions they're not smart enough. Because I think that's where mistakes are made. And that usually brings up some significant issues. They may still go on the other side, may still not like them, that's okay. But what I want people to do is make the most informed decision they can. And that's where I think we help the people rather than go, well, they've got a bad learner, so my job is just to let it lead on one side.
This is a great question. We could probably spend the entire afternoon just on this one question. There's a wonderful book that if you haven't read, I highly recommend it. It was edited by Daniel Bowling and David Hoffman. It's called Bringing Peace into the Room. And there's a chapter or two in there by a fellow whose name I can't remember, Malcolm, maybe you remember, but it's about mediator as trickster. You know what the trickster is? It's sort of it's in different cultures, sort of you can't tell, are they good or are they evil? They do all kinds of things that break the rules. So this was very early in my career. I had a IP mediation, and I'm going to slide in a little editorial comment. The greatest blessing that I can experience as a mediator is when I have good counsel on both sides. Boy, does it make my job and my life easier. In this case, there were multiple parties. There were a lot of lawyers in the room, but there was one lawyer, I forget who he represented, but he was awful. Not only did he not know the law, but he was a grandstander and a foot stomper and a fist slammer, and nobody liked this guy. He was just making everything difficult and making it more likely that we were going to run into an impasse. And so we got to a point where we needed to stop. We clearly needed another day. And the mediation was actually taking place at his law firm, at his office. So I went to his assistant and I said, can I ask you about Mr. So-and-so's schedule? When is he next scheduled to be on vacation? Oh, well, just in another 2 weeks, he'll be gone. I said, great, thank you. Then we scheduled the mediation for during that time with his co-counsel, his associate, and we settled the case quite quickly at that next meeting. Now, yes, exactly. I was being a trickster. It worked. So, just one illustration.
You know, the other thing that I think is possible, and this sometimes happens in a situation where, well, this only happens if both lawyers agree for this to happen. Sometimes I've done situations where, again, the goal is education, where we bring both counsel together and we have them each talk about the law in front of both parties. So this is the old joint session, but differently done, right? With a very specific goal of, if you wanted to educate someone on the other side of this dispute, what would you say, right? How would you explain this to them? And sometimes that can work. You have to clear this in advance with the attorneys because it is a big deal to ask them to step out of their advocacy role and into an educator role, right? Different tone, different orientation. But I've seen it work sometimes really, really well. And it's just another idea for situations where you feel like someone's not getting the correct advice in the other room. And how do we create a situation where it's not the mediator practicing law? Because we're not supposed, right? There's a fine distinction between what we're supposed to do or not do. So we have to be a little bit careful as mediators in those contexts.
I second Claudia's idea. It depends on who the participants are. I had a number of great lawyers, former colleagues of mine, and I became general counsel after hiring them because they were really good. And one of them, unfortunately, passed away a couple of years ago, but I would bring him in a lot of mediations because he could sit across the table from the other side and explain our position in a way that was not belligerent, was not threatening, was not rude, entirely respectful, but he would explain how our side is going to look at the case. And I learned from him. Once in a while, if I could bring him along, I would show up in my client role, general counsel, purposely so the the person on the other side, client, would be able to hear our best explanation for why we did what we did or why we didn't do what they wanted us to do. And there were a couple of just memorable examples where the dynamic shifted dramatically. Remember, my job was not there to say we're going to crush you, here's more money than you, or anything like that. It was to be able to explain sometimes the law, but oftentimes just what's reasonable, we think our position is reasonable. And if you do it in the same way you'd be saying it to the jury, it'll get heard. If you do it in a way that sounds contentious or smarter than you created, it won't be heard. And the key for our job, obviously, we don't get to tell anybody what to do. We want you to make the right decision. And the way that happens is to have everybody listen to the other side. Not just listen to me, Claudia, Stephen, but to listen to the other side, which requires taking the vitriol out and telling a reasonable story. And if you do that well, you know what, people don't just go, sorry, we give up. But it changes the dynamic in a really productive way.
What do you do in situations, talking about jumping off facilitative versus directive, where maybe there's a pro-per on one side and full counsel on the other side, and the pro-per's looking at you like, help me, what do I do here? I don't know what to do. How do you handle a situation like that?
I asked them to get a lawyer.
Good advice.
And if they refuse, then I have, with lots of work with defense counsel in advance, organized a joint session, and the plaintiff has to agree to this too, in which the defense counsel, in their best educational tone, explains how the lawsuit will likely move in terms of proving different parts and pieces of it. That can work, and that cannot work. Or it can work for the first 10 minutes, and then it can go awry. So it's an attempt to sort of be as balanced as possible. And if I feel that the defense counsel in that, I'm just assuming it's a plaintiff who doesn't have the counsel. If defense counsel is not being fair or reasonable or whatever, I'll ask questions or I'll interject. But it's not, it's a really difficult situation, and I think as mediators, a lot of it is about how you view your role. So I've had situations, for example, where a plaintiff is unrepresented and they're mediating very early, so all the information is not out on the table yet. But what is alleged, if it's true, it's easily a $30,000 case, right? Just on the low end. Nothing, it wouldn't be less than that based on what is being alleged. Whereas in the defense room, they're offering, $900 or something. This is a very early mediation. It used to happen a lot at the EEOC when I did EEOC mediations, which is the Equal Employment Opportunity Commission. So that's where you start as a plaintiff when you have a claim of harassment, discrimination, retaliation, before you hire your lawyer sometimes. So in those cases, sometimes the plaintiff would say, can you get me $1,000? If so, that's good enough. And so then I'm in this position where I know their claim is worth about 30, if what they're saying is remotely true. And in the other room, they're offering 900, and the plaintiff is telling me 1,000. So I talked to another EEOC mediation about that mediator about that exact scenario. And he said, hey, if I hear that, I settle that for $1,000, and I'm done. I go home early, right? 7 hours early. And I said, how do you sleep at night if you do that? That just doesn't sit well with me. So for me, I really struggled with this to figure out how to not direct the plaintiff, but to educate them about the bargaining process. Because a lot of times they don't even understand the bargaining process and how this works in a negotiation. So some of the conversations I had involved that. Here's how the bargaining process typically works. You make a demand, they make an offer, I go back and forth, et cetera, et cetera. So that this can take 7 hours of going back and forth. So I'll explain that because that might be new information. I'll also ask questions about essentially getting a damages. How were you harmed by this? You lost your job, you were terminated, you're telling me it's because of your national origin and how they made fun of you because of your skin color and so forth, you know, and that this went on for 2 years and you complained to management. In other words, they have a strong case, right, if in fact what they're saying is true. And I'll say, so what happened to you after you were terminated? And they'll say, I couldn't pay my rent for, you know, 9 months, or I had to borrow money from so-and-so. Okay, so how much did you have to borrow in order to pay your rent? And, you know, 9 months, how much is that? So we talk a little bit about, you know, that. Now, is that coaching in a way that is improper for a mediator? Is that appropriate and ethical? I mean, it's sort of a question, I think. Some of us are going to fall on the line on the side of, yes, you should do that, right? You're balancing the scales of power, the differential between information and knowledge. Other people are going to say no, like that mediator told you about, and he'd settle it for 1,000. So I sort of, you know, those are the situations that I've sort of tried to, or the questions that I've brought in situations where there's a pro se plaintiff, because it is challenging at times. And again, at the end of the day, can you sleep at night with whatever it is you chose to do? I think that that's really a legitimate question to keep in mind for someone.
I refer those cases to Claudia.
So
one question, what if plaintiff's counsel says, and now you're doing the dance, okay, we're in the dance phase, and the plaintiff's counsel says, you know, we've been thinking about this, and if you can get us $30,000, we'll take it, but I don't want you to go to them with that number. I want you to negotiate for us. What do you think of that? Well, do it. You can't do it. This happened recently. I said, you can't make me your negotiator. If you'll take 30,000, I will take it back. See whether I can get that. But you can't say we'll take 30,000, but we want you to go in there and start at 160,000, and then you negotiate. I mean, that suggests to me that lawyers just don't understand.
No, I would say, if what you're asking me is how to help you get to 30,000, and you're at 160, then here are some thoughts about
coaching.
Yeah, how you might think about the negotiation.
Don't like work with me.
Right. No, I put that responsibility back on the folks in the room where I think it belongs.
I think a number of us have seen that happen, and it's always got to be the same. You can't be their negotiator, right? Question?
Well, I guess my follow-up question as a litigator is your advice then, when you go to mediation, to never give your mediator your final best offer? Like, you don't want to give that away. Like, in some situations, I've been in a mediation where I wanted to communicate that information to the mediator and say, you know, this is not where we are now, but we have discussed this, you know, we have this authority, whatever. It's rare, but like, are you saying as a recommendation from the mediator, you don't want to know that information?
No, I don't think we're saying that at all.
Yeah.
I think we're saying, if you think it will be helpful for the mediator to know that. I've had situations where both sides tell me that information partway through the day. You know, at some point, you know, here's where we're trying to get to. You know, what can you do to help make that happen, or something like that. And you can obviously say, here's where we're trying to get to, and don't tell the other side. But I have to say, I also hold that with sort of a grain of salt attitude, because what I'm seeing a lot more of is people using the mediation process to negotiate into a place where they demand a mediator's proposal at the end of the day. So they've told you one thing, but I've seen so many parties do things that are completely radically different from what they've told me their bottom line is earlier in the day, that oftentimes I don't even ask for. Like, sometimes it's not helpful for me. I mean, it doesn't mean anything, is what I mean. But I don't think it's a problem to share that if you feel confident in your mediator.
As long as it's not too soon, as long as it's not too early in mediation. Sometimes people will tell me in our first caucus, well, do you want to know what our bottom line is? I'll say no. Not yet.
Well, the other part of that is people come in with all good intentions, and they think they've diagnosed their case and it's worth X or it's not worth more than Y, and things shift during the day. I mean, I think their perceptions shift during the day. I see that a lot. So, but I work with some very sophisticated counsel who will say earlier rather than later, here's what we're shooting for, and they never say yes, we'll get to be there. But at least a couple of the players are really good at diagnosing value. Now others would say that and go, we're not going to get there. So they want to share, yeah, but to the grain of salt point, you have to respect it, but also recognize things may feel different in a few hours. If people want to give you that commitment, that's great, but I agree with the comment. I wouldn't immediately say early on, this is what we're shooting for.
I wanted to say one other thing about pro-pers. I'm trying to think if I've ever had a commercial case of a pro-per. If I have, maybe I have one, but where I see the pro-pers are in family law cases, probate cases, elder cases, family business cases, the same ones we were talking about earlier. It's quite common, actually, to have a pro-per on one side and a represented party or parties on the other. And the rule of thumb, in addition to what we talked about already in terms of the ethical dilemma of trying to level an unlevel playing field, is to coach the lawyer. Let's just simplify it. You've got a party on one side with the lawyer and a party on the other side who's self-represented. I will talk with the lawyer and just make sure they know not to intimidate the pro-per, how to look at them and smile and be friendly and not try to be the Darth Vader lawyer. It works miracles because people, when they're self-represented and they come into a case, even in a mediation, are intimidated by the fact that the other side is a lawyer and they don't. And it actually doesn't help matters. It doesn't help us get to resolutions. Even in that situation, they're not going to run up the white flag of surrender, but they may get befuddled and they may not be doing their best thinking. So to the extent the lawyer can be kind and considerate and caring, we might actually be able to get that amygdala to calm down and get people into a place of better executive function.
Claudia, a minute ago you made a comment, I think, about somebody saying, geez, I need to get to 50,000 or whatever. Can you help me figure out, or can you help me sort of see the steps to get there? And that's a little confounding to me in a way, because it sort of makes you evaluate the case and give them feedback that you really have gotten from the other room that you probably shouldn't be providing in a way. The flip side of it is when somebody says, I want to, here's what I want you to take back to the other room, and you just know that it's going to go when you take that into the other room. I'm interested in sort of, they're obviously completely different things, but kind of the reaction that you guys would have to each of those, because they're really kind of require different skill sets in order to maneuver.
Yeah, usually what happens for me is they say, here's what I want you to take back to the other room about why we are at this number. So it's very specific information that helps explain the number. And that, I think, doesn't cause the explosion that you're talking about. I definitely, I'm trying to think if I've had information that I thought was going to cause, I think what I say in situations where I think there's a disagreement, I say, I may not take that back, but I will indicate there's disagreement about fact X or situation Y. Because my interest is definitely not in inflaming, except to the degree that it educates. So if they don't understand this important point on the plaintiff side, and the defense room is totally missing it, then I will talk about it, even if it inflames the defense a bit, because they disagree with it so strongly. They still need to understand it, and so that's how I present it. I'm going to talk about something that's hard to hear, because I know you so strongly disagree with this, and here's why I'm going to talk about it. Because I want you to understand legally how this fits into the case and what you're going to have to defend against. So you can give sort of a preliminary sort of statement that helps ease your way into information.
I guess that's presuming that they've given you a rationale for the number rather than it's just, oh, hell, they've come back with X and, we're going to go back with, I had somebody once when I was early in my mediation career who I mediated with now several times, and she gave me a number to take back to the other room, and I heard it, and I didn't say anything. I went back to the other room, and I got that explosion, and I came back, and I said, well, geez, you know, here's what happened. It wasn't well received at all. And she's like, didn't you see that coming? Why didn't you tell me? You know, and so, you know, they're sort of, you know, you're on this continuum. I mean, how much pushback, or, you know, that's really a bad idea to take that number back or whatever. Anyway, it's just, it's sort of hard to know.
And one of the things we can do is immediately react to whatever that is. And what I do, I suspect Steve and Claudia do, is say, well, I can relay that, but let me explain what my reservation is, or explain it further to me. So my routine is, if you really want me to, I will present that, or present this. But you might consider a different approach. And obviously our job is to make sense. It makes sense. If you want to do alternatives, make sense. Because I think part of our job is to channel our own instincts and go, I think this is the wrong chess move. And I want to make sure we have the best chance of you winning or whatever. So a good resolution here. And a little bit as, like everything we talk about, putting our own credibility on the line. I think we should go a slightly different direction. If they're still adamant, okay, I'll go do that. And then we figure out what the step is after that, which usually means going back to what I did before. Yeah, and obviously you can't force people into a certain path. But if we're doing our job well, we're explaining why it really feels like a slightly different strategy or different chess move makes the most sense.
So definitely pay attention to the, are you kidding me? Feeling inside of you. But I've never, ever had a negative reaction when I have asked, okay, help me understand how you arrived at that number. I never want to go into the other room with a number not knowing how they got there, because they're going to probably ask me that. How did they get that based on this, 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 and that? So that's one possible way to go with it. Another one is, this can happen in a number of different scenarios, including the educational piece that Claudia was talking about. But sometimes I find that my job, I'm sure the others feel this way too, is to make sure that the side that wants me to take a number is aware of the possible explosion that might happen in the other room, just based on the number itself.
Yeah.
Right? What do you take me for? Right? I mean, so numbers are encoded messages, and we have to try our best to put ourselves into the shoes of the people who will be on the receiving end, and try and do our best to guess how they might respond to that. So I'll even ask this question, and again, I've never had a negative response to it. How do you think that will land in the other room?
Yes, exactly.
Right? So,
Well, what about the difference between that question and, you want me to tell you how I think that's going to land in the other room? Because they may not know, but you do.
yeah, no, I'll ask first, but if they say, I don't care, I don't give a damn, or they make a guess and I don't agree with it, so, well, okay, that might be. Let me tell you what my thought is, because I've spent some time in that room. Here's how I think it might land. So the next, I'll get to in just a second. The next piece is, I will ask a question like, how can you come up with a number and perhaps an explanation that accompanies the number that will communicate the message you actually want to communicate? If the message you want to communicate is, I have no respect for you and I don't think this case is going to settle, then you might send a particular message or give a particular number. But if the message you want to communicate is, I think we're far apart, but I think we can get this done, and this is where I'm at now. I don't want you to walk out, but I know this is probably going to be a lot lower than you want it to be, or higher than you want it to be. That is a way to mitigate the possible collateral damage caused by the number that you bring over, and it just, you stepped on a landmine. I know you've had a question.
Yeah, I do a couple of things. I don't ask, how did you arrive at that number? Because I do share in caucuses that initially, my experience as neutral is parties attempt at the beginning of of negotiations to tie their demands or offers to a particular set of facts. This is why I'm doing it. But you can only do that a few steps in the negotiating process, and then you are left with, there's a magic number that one side will go, and accept, and the other side will go, and offer, and it has no more validity than $1 more than that number or $1 less. It's just the number that they'll agree on. I do use a statement, and sometimes I share a war story to be able to illustrate it. But I say, the rule of thumb in negotiations is you make them go, but you don't make them leave. And if you think, as a mediator, that the result of communicating what they're instructing you to present in the other room is going to result in the other side packing up and leaving, I have said I'm not willing at this stage to go into the other room and present that because based on what I'm hearing in the other room, I am afraid that that will be incendiary and it will cause the mediation to come to a grinding halt. Is that really what your intention is? Or do you want to see this matter continue with negotiations to bring about an effective resolution?
Yeah, I think we're saying a lot of the same things. The other point I wanted to make was that educational piece, and that is that sometimes it can be very helpful to caucus with the lawyers without the parties present. And this is where a lot of educational activity can take place, filling in gaps. Well, you're aware of this case, or I see your point, but this witness can say this. But also a lot of practical information sharing can take place. Client control issues can be discussed in private. I'm a big fan of those meetings. I mean, just doing even decision trees with the lawyers that they can then communicate to counsel to their respective clients. That's another way to deal with what could be incendiary offers and counter offers. Is talk about it first with the lawyers.
And the other thing that I want to mention, because I really do think they're magic, are high-low brackets. How many of you are using high-low brackets in your mediations? So not 100%. But do you all know what it is? Or is it something that you're not familiar with the term?
Why don't you describe it?
Describe it. Okay, so high-low brackets are hypothetical ranges. So I'm the plaintiff and I say, okay, I'm going to give you a high-low bracket of, if I move down to 500,000, defendant, will you move up to 100,000? So the bracket is from 100,000 to 500,000, and it's purely hypothetical until somebody on the other side accepts that bracket. But the beauty of this is, I really do think they're magic, because it separates people out from a number, a single number, and it creates a range of possibility. And something about that unhooks our, focus, or at least this has been my experience, the focus on, this one specific thing. And so you end up taking a high-low bracket into one room, and then you get a new high-low bracket, you come back to the other room, 200 to, 300. Or 75 to 300 in that room, and and slowly these brackets begin to move. They're all moving slowly together. You frequently do not end up in one perfect bracket, but something about that process allows both sides, right? You're talking about the midpoint. The midpoint of each bracket is a signal, and I always, make sure this is what you're signaling. You're signaling you would settle for this number in the midpoint. Okay, so you know that, yes, okay. So something about that process, though, releases us from this tit for tat back and forth, and magic happens. Settlements occur in ways that I would not have expected. So I just wanted to make sure that you're all aware of those.
I was going to say, I'm a huge fan of it, although having just led a roundtable with a bunch of neutrals on the topic of bracketing, it was very interesting to see why array of opinions, with people saying, I hate bracketing, they never work. And I say, I use them almost all the time, they work really well. And after some back and forth, I think one of the reasons they work is it relies upon us, obviously, coming up with a bracket that we can make sense of. And it takes the sting out of either side saying, well, that's the number, it's only worth X, or no, it's worth 10 times that. So we own the responsibility of moving that dialogue along. But I remember from that back and forth at the round table we got on this topic, one person I didn't know the neutral said, I think it works when you have credibility, you the neutral have credibility in your audience. And I think you kind of nailed it. So we have to be able to, in credible ways, say, based on what I've heard, read, 20 years of doing this work, I think these are reasonable bookends. And obviously we're putting ourselves on the line when we do it. And I find that it is a very effective tool to add some rationality, taking a little bit of the sting out of, they're not going to tell us it's this low, they're not going to tell us it's that high. So, big fan, big fan.
Well, thank you, everyone. I appreciate the interaction, especially. Great crowd. Wonderful, wonderful panel. So thank you.